An absence. All right, let's go ahead and call the roll then after saying good morning. Um, the chair is present. Commissioner Baker,
Here.
Commissioner Bluestone,
Here.
Commissioner Castillo,
Here.
Commissioner McMillan,
Here.
and Commissioner Villanueva, the birthday
Here.
girl. All right, that bit of business being out of the way, is there a motion and a second to approve the agenda?
So move.
Second.
All right, and is there any discussion, any opposition to approval of the agenda? Is anyone opposed? Okay, the agenda is approved. Approval of the meeting minutes of the December 5th meeting, which was our most recent one. Is there a motion and a second?
Move to approve the minutes.
Second.
Any opposition? Okay, then the minutes of the December 5th, 2025 meeting are hereby approved. Item number 4, General Counsel's initial observations. And Zach, I believe this is you.
It is. Thank you, Mr. Chair. Commissioners,
you.
I want to thank Commissioner Baker for the opportunity, having the idea for me to share my initial impressions. And I looked at my calendar because I was curious, and I think the timing of it is appropriate. Exactly 1 year ago today, I was flying back to Iowa after interviewing and getting my very first impression of the Ethics Commission. So I've had exactly a year to form this impression. I want to start with some similarities between the Iowa Ethics and Campaign Disclosure Board and the State Ethics Commission. Some of the reasons why I wanted to come down here and work. First and foremost is the leadership, the commission, and the agency overall. It's people who focus on the law and not politics. There are instances across the country where agencies such as this are being weaponized for the pursuit of political power. There are agencies that can't get anything done. I don't think the FEC has had a vote that is not party line in far too many years. Up in Iowa, we actually hold the record for the longest serving chair of any ethics commission in the country. So, Mr. Chair, you have some work cut out for you because my old administrative.
That is, I'm not a record pursuer.
Well, that's a good thing because my administrative law professor, the chairman, Jim Albert up there, has been the board chair since 1997. He's been appointed by every single Republican and Democrat governor since then. And it's a reflection of the bipartisan respect that board has, which is definitely a similarity that I found down here in New Mexico. Another similarity is the quality of the leadership in the agency. The other directors up in Iowa, not myself, have gone on to serve as chief counsel to the chief justice. They are seen as just a reliable legal mind. My predecessor in that position had been the 20-plus year Secretary of the Senate, bipartisan, rehired by both Democrats and Republicans. So that's another similarity that I found down here. Another area that Iowa does well, that I think New Mexico does well, is being seen as a resource for people across the state. I think particularly the compliance division in New Mexico beats out the compliance division in Iowa based off of the amount of work it does, the quality of work it does. But one thing that's shared between both states is that if you have a question, you can rely on the legal opinions of the ethics agency, and they're going to get the law right. Another similarity that both agencies have faced, I know, are sometimes threats. This is an interesting time to do this work. Back in Iowa, I even had candidates threaten me in certain instances. And we don't need to get into the examples of what we know people have been down here in New Mexico. I think it's a reflection of the times we're living in right now, and also the increased amount of work that we're doing. Increased money in politics that's not anything that's slowing down anytime soon. Another impression that really appealed me to this agency was also the investment in technology and the ability of it to function a lot more like a small, scrappy startup or small business as opposed to some large, meandering government bureaucracy. Growing up, my dad was a small business owner, and I liked the agility that being an agency of this size gives us. Some differences and what I think New Mexico does particularly well. The Iowa Ethics and Campaign Disclosure Board was established in 1993. It was originally established in 1973 as the Campaign Finance Disclosure Commission. It hasn't really changed too substantively since early 1990s, and even the current staff composition reflects the original 1973 designation, because the majority of the staff at the Ethics Board are campaign auditors who review campaign finance reports, flag irregularities, and provide support for candidates and political groups who have to comply with the state's campaign finance laws. There's only 2 attorneys, and there was only a second attorney added in 2020. So just by that one metric, New Mexico blows Iowa out of the water. And in my former position, I actually served in both the director and counsel statutory roles as a cost-saving measure. So it was much more of a bare bones operation up in Iowa than what we had down here in New Mexico. The way I've been describing New Mexico for more than a year is it seems to function like a small, independent, specialized attorney general's office. Given the quality of professionals that we have here. And the result is that we can do a lot more work that I simply wasn't able to do in Iowa because we didn't have the bandwidth for it. And lawsuits that should have been filed that ultimately weren't, that I wish could have been. But it's one of the things that I think New Mexico is doing well, and it's exhibited by some of the work that we'll see later in this meeting today. Another difference that I think New Mexico does well is the composition of the board. First and foremost, I'm very glad that we have an odd number of commissioners to avoid the potential for a tie. It's also bipartisan. One thing that I know has been on the minds of some of the commissioners is the voting structure up in Iowa. It's just a simple majority. There is a law that requires no one political party having more than a simple majority of seats on the board. But other than that, the vote is just a simple majority, and you don't need any kind of party affiliation requirement to get a measure passed. Another difference is the appointing authority. There is no variety of appointing authorities in Iowa or in a lot of other ethics commissions that I've seen across the country. It's just the governor with Senate confirmation. But let me tell you, when you have a supermajority in the Senate that is the governor's party, a lot of times Senate confirmation is just nominal at best. And as a result, sometimes you don't get things done, or we've even had an empty seat up in Iowa since 2023. And I did my research on that back when I was director. That was unprecedented to not appoint an open seat to the ethics board. And as of 2026, that seat is still empty. It is something that the current governor has done with several boards. And in my humble opinion, I think it is ultimately a tool to undermine the work of those agencies and to ensure some favorable outcomes, unfortunately. Another big area that New Mexico is doing well is the budget and the support from the legislature and other parts of the state. I looked at the state budgets, and Iowa and New Mexico state budgets for the current fiscal year are very, very close. New Mexico's at 10.9 billion, Iowa's at 11.5 or 11.05 billion. But the budget here is almost double. When I started in Iowa in fiscal year 22, our budget was just over $700,000, which also represented a significant increase over the past few years. And we were able to get that budget over $1 million by the time I left. But it's still not the same amount of investment that we have here in New Mexico. And at the end of the day, sometimes you just get what you pay for. And I know for myself and for my deputy who left around the same time as I did, being young people, and for her, it was a growing family. If you can't pay people enough, and if you aren't even competitive with other government attorney positions, it's hard to recruit and retain people, because we're not in this for the money, but at the same time, we still got bills to pay, and those bills are not getting cheaper. Another difference that I think New Mexico has done well, which I have not noticed, thankfully, in the past year, are the more existential threats to the Ethics Commission's existence. During my 4 years as director in Iowa, we had repeated attempts from different commissions, from the legislature, from the governor, from outside special interest groups who tried to curtail our agency's authority and reform it in a way that would make it significantly less impactful in enforcing the government ethics and campaign laws. And it's not something that's happening only in Iowa. It's something that I think is a trend in several places across the country. In Kansas, their government ethics commission has been demoted just in the past year to the Public Disclosure Commission. It was a result of the director investigating the legislative leadership who were involved in covering up campaign finance money. And the general counsel at Kansas, who was also no longer there, described it, I think accurately, the bill that went into law, as a major blow to transparency and legalizing the exact kind of criminal activity that the director was investigating for the legislative leadership. You'll hear horror stories from other places too of directors being trailed by private investigators who are hired by the people they're investigating. And thankfully, I have not seen that kind of open hostility from other parts of state government here in New Mexico. Um, so even though some older agencies like Iowa and Kansas have been facing some difficulties, even compared to a contemporary, the North Dakota Ethics Commission, which was founded in 2018, New Mexico is doing very well. North Dakota, excuse me, their staff only has 3 full-time members on it. And so the level of investment, again, sometimes you just get what you pay for. And here we're able to do a lot more work and answer a lot more calls from the public as a result of having more bodies in these chairs. There are issues here too, but a lot of the issues that I found in New Mexico are frankly not issues that go away when you cross state lines. It's inherent in this kind of age-old problem of trying to curtail the power of a select few who are able to get it. Another thing I was able to do back in Iowa was host delegations from Kazakhstan, Jordan, and the Philippines, and plenty of other places. And we really do have so much more in common when it comes to the area of government ethics and campaign regulation than we would think, even with places on the other side of the world. Even the Ukrainian delegation, when I hosted them in 2024, the year before, they had just passed some legislative lobbying reforms to make lobbying at the federal and the oblast level much more transparent. And we even have a bill before the New Mexico legislature right now, which would help accomplish that here. So we have a lot more in common than we think. But ultimately, I think the initial impression that I had of New Mexico and the reason that I wanted to come down here, the rather high expectations that got me to leave my home and what was a dream job, they have proven true. I think this ethics commission, and as a result, the landscape of government ethics in New Mexico is really on the cutting edge, not only for state counterparts, because all of this is to say nothing of the government ethics landscape at the federal level, which I will not get into unless we're going to save that for discussing it over many, many drinks. But it's a good landscape. I think we just ultimately have a lot of momentum, and I think we're going to accomplish a lot more. There's a great landscape and a lot more to build on. So with that, we can get back to the work.
Thank you, Zach. We all really appreciate that. I have one question. So on the other side of that, have you enjoyed your move to a completely different landscape, geographics, cultural?
I have, doing the drive up to Raton for this trial we have next week a couple of times. It's a drive I'm looking forward to doing again this weekend. Once you drive through land that is just flat, no matter how beautiful it can be, once you've driven through something that's been flat for 30 years, it's nice to have some mountains and nice for a literal change of scenery. And there's a reason why they call it the land of enchantment.
Right. Good. Anybody else have anything before we move on to the substance of the program? Yeah, Stuart.
Yeah. First, I want to thank Coach Baker for asking Zach to do that retrospective, and I want to thank Zach for doing it. And it's helpful to hear. I appreciate that. You mentioned a couple of things that I would like to comment or ask about. The comment you made about our compliance work and the turnout that we do with those informal advisory opinions, I'm just so impressed with both the quality of the work and the turnaround. And I compare it to what I know was a chronic complaint about getting opinions out of the Attorney General's office, which I think is still probably the case, although I don't know that for a fact. But I really have great respect for the work our staff is doing on turning around these requests for informal advisory opinions, many of which we convert to formal commission opinions. And I think that any involvement you can continue to have with that, Zach, should be encouraged, because it's a real feather in our cap as a commission to get the reputation, well deserved, for turning those opinions around and giving them such good quality. The question that I had is, when you referred to the threats to these ethics commissions, and we know what's happened, as you accurately pointed out, in other commissions around the country, it reminds me to ask, and maybe it's more appropriate to direct this to Jeremy than to you, Zach, but we had a series of threats made to our staff. And we had a lot of spam. We had personal visits come. We had to increase the security level for our staff at the office. And I'm wondering, has there been any a continuation of that problem? How successful is our staff in dealing with it, and how chronic is the threat and the nature of it that we're facing?
If Jeremy wanted to jump in, otherwise, I would say that I think it was the first question that I asked in the interview a year ago. It was, what security measures are in place? Because I had to have the State Patrol on speed dial oftentimes to escort me to my car back in Iowa. People would be waiting outside of the office. It was something on my mind, and certainly something my mother wanted me to ask about too. But from my impression, I think it's been handled at a professional level in the best way you want it done. The investments done have made me feel so much safer in our offices than I ever felt back in Iowa. But for any other comments, I'll refer that to Jeremy.
Thank you.
Thanks, Zach. Thanks, Commissioner Bluestone. The building is much safer than it used to be. We're behind two sets of locked doors that are key card access only. And we have an intercom system at the front door, so we're not exposed to the same risk that we used to be. The threats and kind of hate messages do continue, and Amelia is really in the best position to speak to this. But what we noticed recently is, after some of the events that got a lot of national coverage in Minneapolis, we noticed a spike of messages and calls. I received calls to my work mobile after that, and I believe we got a spike coming into the main commission line. And I just think that that's because the main doxing video that's kind of floating out on the internet, it gets, the algorithms drive it when we're in a kind of a moment of more contestation. And so I think that when the country kind of goes through convulsions of highly contested events, that the algorithms drive that doxing video, and that results in more messages coming in our way. But Amelia, would you like to add anything to the traffic of kind of hate messages we've been getting?
Thanks, Jeremy. I think you covered it well. In general, the sheer volume is on a decline. From the time we got it to today, it's precipitously less. But we do still, as Jeremy mentioned, get the phone calls, get voicemails, and when there's kind of a spike in the temperature of the outside world, we kind of see that reflected in the phone calls that we get.
Thank you.
Anybody else? Yeah, Jeff.
Yeah, I want to ask Amelia, when you get these phone calls, is there a common theme that these callers think we're doing wrong, or that?
There's just a sense of mistrust. Often they are out of state phone numbers, and so I don't answer them, and often get the voicemail. And so I'm not ending up talking to these folks directly, but every now and then it does happen. And interestingly enough, when you say I hear you, and I can understand why that would be frustrating, they actually end up being okay with the scenario, and thanks for hearing me out. So it is kind of an interesting dynamic where they come on with a lot of gusto, and then when they feel heard, the temperature lowers almost immediately.
That's good to know. Thank you.
Anyone else?
Yes,
Judy.
Chairman,
Judy.
I had a question for Amelia. Do you do you recognize these voices and do you report them in such a way to the authorities so they can trace them, the calls?
Yeah, thanks, Judy. We are still tracking them all. And so the IT provider that we use, Real-Time Solutions, they have developed a dashboard where we can send all of these voicemails. So we do have a complete log of every voicemail we've received. I don't recognize the voices. It's also just not something I'm keeping close enough tabs on to know if these are the same numbers calling or same people. And last year we did report the phone calls. Jeremy could speak to all of the entities that were involved, but we do have it all documented. And right now, I personally don't feel at risk, especially with the security measures that we now have in place at the office.
Great. Thank you, Amelia.
All right, anyone else? Okay, thanks, Amelia. As always, thank you very much for your assistance, and Jeremy, and thank you, Zach, for the report. Okay, item number 5, Casey.
Casey, before you get started, can we introduce Grace since we're kind of doing
Oh, right. Yes, please.
non-substantive stuff? Great. Grace, could you turn your camera on? Okay, wonderful. Commissioners, this is our newest attorney hire, Grace. Grace Sue. Grace is a talented young attorney. She went to the Albuquerque Academy, and from there to the University of Chicago, and then from there to Vanderbilt Law School. Grace is a New York lawyer, which is curious, but she practiced law in New York for New York Legal Services and New York Housing Court, and came back to New Mexico not too long ago, worked for the Attorney General's office, and then has come over to the State Ethics Commission. And I think Grace is maybe in her second week. She's learning our laws, and we're giving her the time and space to do that, and the opportunity to do that by drafting some initial opinions. The opinion that I'll introduce here in a minute, Grace also had a chance to review and work on. And I think that Grace is going to be a tremendous asset to this agency in years to come. I hope she stays and carries the work forward for many years. So Grace, welcome.
Well, thank you for that very generous introduction, Jeremy. It's so nice to meet all of you commissioners. I'm really excited and honored and grateful to be here. Happy to be back home and serve my home state. And I just am so enamored by everyone in this office, and the quality of work and their kindness and their support has just been amazing. So yes, Jeremy, I would love to stay as long as I can. And I'm very excited. And it's very nice to meet all of you.
Well, thank you. It's nice to meet you, Grace, as well. It's also nice to have another Charger in the lineup here. But my years were spent at the Albuquerque Academy for Boys. It was an all boys school until the semester after I graduated. So it's now a more civilized institution, doubtless. But thank you and welcome.
Meeting Grace, Judge, is reminding me that maybe we ought to try and set up another in-person meeting in not too long to get a chance to say hi to everybody in person.
Jeremy and I have spoken about that. That's coming up. I think we'll probably do that. We'll probably do that in June. So, all right. Anyone else? No, thanks. Everybody wishes you well. All right. Now, Casey, I think.
Chair, commissioners.
There you are.
So I'm here today to talk about the Open Meetings Act. As you're all aware, the public policy of the state is that all meetings should be open for public entities discussing public business, unless there's a specific exception to that rule that allows for a meeting to be closed. Part of the Open Meetings Act is that annually the commission is required to determine what notice is reasonable for the commission. And what you have before you today is the commission's annual Open Meetings Act resolution. The notice provisions are the same as they were last year, and they're based off the recommendations from the Attorney General. There are three kinds of meetings: regular meetings, special meetings, and emergency meetings. Regular meetings are held every other month, subject to the call of the chair, and as well as any other regular meetings that might come up that might be necessary. For those, notice requires 10 days before the meeting, notice is posted. 72 hours before the meeting, the agenda is posted. Notice includes broadcast stations licensed by the Federal Communications Commission and newspapers of general circulation that have provided a written request for such notice, and the agenda is posted to the Commission's website. Special meetings that come up that may be more urgent, that you may not have those 10 days, require at least 72 hours notice, and that's 72 hours notice should include the agenda. Again, it goes to the broadcast stations that have provided a written request for such notice, and the agenda must be included as well. And that has to be up 72 hours in advance. The final set of meetings are emergency meetings, which I don't anticipate the Commission will have, but it is possible, so it is included. And those are only called under unforeseen circumstances that demand immediate attention to protect the health, safety, and property of citizens, or to protect the public body from substantial financial loss. And those meetings are allowed to be called with 24 hours notice. And it's got specific notice requirements. Telephone notice must be given to those broadcast stations and newspapers that have provided a written request for notice of meetings. Notice for all emergency meetings must include an agenda, and within 10 days of taking any action on an emergency matter, the Ethics Commission must notify the Department of Justice of the action taken and the circumstances that created the emergency. And so those are the general notice provisions. The notice or the resolution also identifies closing meetings. This is based on the requirements of the Open Meetings Act itself, and the sections that permit the Commission to close a meeting, such as litigation, administrative matters, personnel matters. And so with that, I will stand for any questions.
Thank you, Casey. Is there a motion and a second to approve the resolution?
Move to approve.
Thank you. It's been moved and seconded. Any discussion? Yeah, Stuart?
Yes, thank you, Casey. I know we don't have the Open Meetings Act under our list of statutes to administer and enforce, but I'm wondering if you could comment on your understanding of the compliance or lack thereof that there is statewide, if you have any sense of that, or if you get requests for informal advisory opinions that impact the Open Meetings Act. And I just wonder what your sense is of what's going on around the state, both at the local government and at the state level, for compliance with OMA.
Yeah, so Chair Commissioner Bluestone, you're correct. The Open Meetings Act is enforced by the Attorney General. And so we do get occasional informal complaints about it, is primarily where we see those. And those will refer over to the Attorney General and the Department of Justice. But beyond that, we keep up with case law if there are cases that are filed, but mostly to see how those affect or potentially affect the Commission.
And do you have a sense from questions you get, either at trainings or otherwise, how much compliance there is, how many issues arise regarding open meetings in our state? Do you have any sense of that at all?
Chair, Commissioner, I beyond the occasional informal complaint that we'll get and redirect, that's about what we see. We see a lot of complaints also about the inspection of public records. That also goes over to the Attorney General. So I know there are people who are watching and there are people who have concerns with compliance, but I couldn't tell you how widespread that concern is, because we don't have really a larger picture of that.
Yeah, I know, and I don't think we're in the business of looking for proper work, to add this into our jurisdiction. But I was curious as to what was going on with it. But thank you for that information, Casey.
Jeff?
Yeah, I'm looking at the resolution, and it says that with respect to regular meetings and regular meetings than those described in the preceding paragraph and notice of special meetings, they'll be given to newspapers of general jurisdiction and to broadcast stations licensed by the FCC. When those newspapers and broadcast stations have made a written request. So as I understand that, if a TV station, a radio station, a newspaper makes a request to get the 30-day or 72-hour notice, we provide it. Has any newspaper or has any radio station ever made such a request?
Chair and Commissioner Baker, I would defer to our Deputy Director on that. I'm not sure. And this may be something that happened before we came on board. We do have a notice of interested parties, and so we send out notice to anybody who's requested to be on that list. So I can't tell you specifically about whether or not it would be any broadcast stations or newspapers. I believe that a number of our notices go to those individuals, as well as other people who've requested notice as well.
Thank you, Chair.
Amelia, yeah, thanks.
Casey summarized that really well. We do have a few of those folks that are on the interested persons list. And as Casey mentioned, we send those out prior to every meeting.
So, for example, is the Albuquerque Journal on that list?
I can, if you'd like, and thank you, Chair, and thank you, Commissioner. I can share the list of interested persons. I'm not sure exactly off the top of my head, but I do believe the Albuquerque Journal is on there.
Okay, yeah, I'm just curious. We have that provision. If you ask, we will provide. I'm just curious, does anybody bother to ask? But thank you.
And
Chair Commissioner Baker, I would note that is a requirement under the Open Meetings Act itself, is that notice be required or provided.
If they request it.
Yeah.
So
yeah.
Just
The
curious.
notice shall include broadcast stations licensed by the Federal Communications Commission and newspapers of general circulation that have provided a written request for such notice.
Right.
And Chair, Commissioner, since I've been on, I haven't received any new requests about being added to the interested persons list. I inherited the list when I joined, and there are probably close to 30 folks on the list.
And so presumably we're providing that information to folks who have not requested it because we think that's the right thing to do. I'm guessing. I'm just asking, is my guess correct? If you know.
Commissioners, yeah, again, that would be before Amelia board, and
That's fine.
so we could go back and dig through and let you know which ones were requested and which ones weren't, but we certainly include people if they've requested it.
Of course. All right. Thank you.
Anyone else? All right, let's go ahead and call the question then. The motion second to approve the annual open meetings resolution as presented. Commissioner Baker?
Without being difficult,
Too late.
I will vote yes, even though my vote does not count.
Thank you. Your flexibility is one of your more enduring qualities. Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Villanueva?
Yes.
And chair votes yes. Thank you, Casey, for keeping us on task as always. All right, next is item number 6, advisory opinion number 2026-01, regulating conflicted votes of attorney legislators. Jeremy.
Thank you, Chair and Commissioners. Among the advisory opinions that the Commission has issued, this draft that's before you is on the more significant end of those opinions, I think. It's a request that is very much of the moment. And I think if the Commission issues this opinion today, or whatever opinion the Commission issues, it will reverberate in the Roundhouse during this session. To provide some context here, a bill to change the Medical Malpractice Act is on the House floor calendar now, HB 99, and is anticipated to go over to the Senate in the remaining week of the session. And I do think that the members and their staff and council service will take note of any action that the Commission takes today. So that gives you some context for this opinion. The question presented that we were presented with is exactly the one here on page 13 of the public materials. Given the provisions contained in Section 3A of the Governmental Conduct Act, would it constitute a violation of the Governmental Conduct Act for practicing attorneys serving as legislators who have personally benefited from and stand to further benefit from lawsuits alleging medical malpractice to vote on measures related to caps on judgments and or settlements stemming from such lawsuits? And I believe the answer to that question is no. A conflicted vote by a legislator, it might constitute a violation of one of the rules of procedure of the two chambers. But in my view, and in the staff's view, it doesn't make out a violation of the Governmental Conduct Act. And here's the reasons why. So first, the Commission has hinted at this answer in prior advisory opinions. The Commission's never been as asked as straightforwardly as it has been in this advisory opinion, but in various of the Commission's speech or debate advisory opinions, and the Commission has seen questions about conflicted votes before, the Commission has hinted at the position that this opinion takes more straightforwardly, which is the Commission has opined that the Governmental Conduct Act doesn't require a legislature to refrain from voting on legislation that implicates a conflict of interest. And while the Commission has never given the full explanation or never had the opportunity or occasion to give the full explanation for that answer, this advisory opinion does it. And here's the analysis. The Governmental Conduct Act, it has an express provision requiring recusals and disqualifications from votes. And that's in Section 4B of the GCA. The 4B provides that a public officer or employee shall be disqualified from engaging in any official act directly affecting the public officer or employee's financial interest. That disqualification requirement, however, does not apply to the members because Section 4 doesn't apply to the legislators because the legislators are not within the definition of a public officer or employee. Where the Governmental Conduct Act regulates the members, it does so expressly in Section 3 and in a few of the other sections of the Governmental Conduct Act. But the main provision of the Governmental Conduct Act that imposes a recusal requirement on government officials and employees, it doesn't apply to the members. And Section 3 is the most general description of the duties that the Governmental Conduct Act imposes on all government officials and employees, including legislators. And under ordinary canons of statutory construction, when there is a general regulation and a specific regulation, the specific regulation controls. And in cases where Prosecutorial offices have a charging decision. They are limited to charging the more specific prohibition. And we've cited some of the law on statutory interpretation with respect to general and specific statutory provisions, and that's reflected in this advisory opinion, the Cleve case, citing back to very old New Mexico case law from territorial days. That's the statutory interpretation basis, but there's a second and more fundamental basis, and it's that the Constitution, I believe, commits to each chamber both the authority and the responsibility to enact its own rules of procedure and the exclusive authority to enforce those rules of procedure with respect to votes vis-a-vis each chamber's own members. And that's sections 11 and 13 of Article 4. Section 11 is the one that states that each house can determine its own rules of procedure. And Section 13 is the speech or debate clause that we've worked with so much in the commission that says that the members, for their votes, can only be called to question in their own chambers and nowhere else. And so reading these constitutional provisions, I don't believe that the legislature as such can regulate the rules of procedure of each chamber. Each chamber can only regulate its own rules of procedure. And that principle of parliamentary practice and of legislative authority is reflected in the kind of standard treatise on this matter, Mason's Manual, and the advisory opinion points to that. And indeed, each chamber has issued regulations for its own members regarding their votes and regarding the process by which members can excuse themselves from votes. Each chamber has different procedures with respect to that. And each chamber has also incorporated as the default set of rules, Mason's Manual on legislative procedure. And Mason's Manual includes provisions with respect to challenging conflicted votes. And the advisory opinion points to all of that kind of parliamentary law and parliamentary practice. And it does so to kind of give the requesters of this advisory opinion an indication that perhaps this question is already and certainly much better addressed by the interpretation of their chamber's own rules, as opposed to the application of the broadest provisions of the Governmental Conduct Act. It doesn't give the full kind of parliamentary analysis after delving in kind of deeply into the question. The advisory opinion says we stop our inquiry there. The interaction of Mason's Manual and the legislative rule set is ultimately a question for parliamentarians in the Roundhouse and the legislative officers in charge of any points of order, and ultimately each body itself. And so I think what the commission is doing here is just kind of signaling some work about how the commission thinks that conflicted votes are properly regulated and questioned and challenged and enforced with respect to the Constitution and the chamber's own rules. But we are not the Senate parliamentarian. We are not the House parliamentarian. Those aren't even offices in New Mexico. But someone that is not the State Ethics Commission is responsible for the ultimate interpretation of each chamber's respective rule sets and how they interact with Mason's Manual. And all of that is supportive of the commission's conclusion that it's really not a matter for Section 3 of the Governmental Conduct Act. The regulation of conflicted votes by members in the bodies in the Roundhouse is constitutionally committed to each chamber, is subject to their own rules, and in the weeds, how those rules incorporate the default procedures in Mason's Manual of Legislative Procedure. And with that, Chair and Commissioners, this is the advisory opinion you have before you.
All right, thank you. Is there a motion and a second to approve and issue the advisory opinion as put forth?
So moved.
Second.
Thank you. Discussion? Stuart?
Thank you, Judge. Jeremy, excellent opinion. Thank you. One question, well, a couple questions. First, could you comment on anything you learned from either the former or the current director of the Legislative Counsel Service when you reviewed this with them?
So I've reviewed this question both with the former Counsel Service Director, Raul Burciaga, when he was director, and have spoken about this question also with the current director, Shauna K-Spear. Raul is the person who really taught me that in previous advisory opinions, we used the word recusal of votes for the members, and Raul kind of tutored me that that's not actually correct, that the members don't just recuse, they can be excused if they ask for excusal. And this was before the most recent amendments to the Senate Rules of Procedure, but it's still the case in the House. And yeah, Dr. McMillan, I think I have this right, but under the House rules, the members have to request excusal from the body, and that's subject to a vote. In the Senate more recently enacted a rule that enables the senators, I think, to just excuse themselves and for a certain delimited set of reasons. But Raul was the person who kind of instructed me on that, on the difference between recusing and requesting excusal, and also is the person who first pointed me to Mason's Manual of Legislative Procedure. And that was some time ago, back when Raul was still the director. And then more recently, Shauna K-Spear and I have discussed this question, and Shauna is in full agreement with the analysis that you have before you and the reasons and his conclusions.
Thank you. The second question is more broadly directed not only towards you, but maybe better towards even Celia or Judge Lang or Dr. McMillan. But do you have any knowledge of when either House or Senate members have sought or been excused on votes in the past? Because the only thing that I can recall over the years I was up there in the Capitol was one year when former Senator Janice Pastor exercised her right not to vote on I think it was a mandatory mammogram bill, because her husband was a radiologist, Dr. Stuart Pastor, and she felt that it was inappropriate, or she had a conflict, because if she voted on it, he would earn more income by doing more mammograms. But that's the only time I can remember a member actually doing it. And I wonder, Terry, Celia, Bill, those with more experience in the legislature, if you can recall of any instances where that was done.
I have seen it recently. Senator Cedillo Lopez excused herself from a vote on recent legislation that increases the salaries of judges on a straightforward conflict reason. And
because her husband's a judge, is that it?
Yeah, Judge Victor Lopez, yes,
Right.
That's correct. And so I've seen it in the Senate on the Senate floor within the last few sessions.
Yeah, Stuart, I've seen it many times over the years, and it's usually correlative to somebody's direct means of income or their spouses. Where it gets murky, and what this opinion goes to, and it's frequently where the rubber meets the road, is where it's a legislator attorney. It's a little less murky when it involves you know, if it's a rancher legislator recusing from a bill that would provide some sort of subsidy to a ranching community as a bad example. But where 99% of the conflicts that I've seen arise in any legislative situation have to do with attorney legislators and their representation, which this is just yet another one of those. And how those are resolved, I guess, are really just led up to an individual's conscience or own ethical compass as opposed to moral compass. And hopefully with the consultation of colleagues and the head of the council service and perhaps the Legislative Finance Committee, but it's not unusual.
And I can't add anything to that. I haven't seen it. The other members of the commission have seen it. So, and it seems to me that what Mr. Chairman has said is right. There are certain cases that seem pretty clear, other cases are not so clear, and it's left up to the individual to figure that out.
Anyone else? Yeah, Jeff?
Can you tell us who requested this advisory opinion?
Not in open session, I cannot.
All right.
Anyone else? All right, let's go ahead and call us to a vote on advisory opinion 2026-01. There's a motion and a second to approve and adopt and approve and issue the opinion. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes, and well done.
Thank you. Commissioner McMillan?
Yes.
Commissioner Villanueva?
Yes.
And chair votes yes, and I would echo that sentiment. Well done, Jeremy. Thank you. All right. Turning it over now to the e-powers that be. Anybody signed up for public comment, Amelia?
Thank you, Chair. The commission did not receive any written public comment prior to the meeting, and looking at the participants, I'm not seeing any members of the public here today.
All right, let's give a second. Anybody want to raise your electronic hand? All right, hearing nothing then, let's the chair will entertain a motion to go into executive session pursuant to 1015-1H3, 1015 CH7, 1015 H12, etc., to discuss the matters identified in sections 8 and 9 of the agenda. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Villanueva?
Yes.
Chair votes yes. Okay, into executive session. Look for your button to go into your room, please.